All right, morning everyone. Let's make a start. My apologies. The 221 121. There we go. That's better. Hope you had a good break and a good reintroduction to contract with Marcus last week. As you'll be aware, I will take you this week, and then Marcus is coming back next week to start on mistake, and then you'll finish up the semester on terms. So, as I understand, last week you finished frustration, right? So you worked on a problem exam question, and you saw how a contract can be determined not to apply anymore or at an end because there's a circumstance that renders its performance impossible. Right, so that's another example of the ways in which a contract can end, and which is a kind of a common theme that you will have seen throughout the semester. Right, you can cancel because one party has done something. You can cancel because something has happened outside the scope of what both parties could have predicted reasonably. You can also have a contract declared void because there were some vitiating factors in the conception or the making of the contract, right? The idea of some inappropriate influence or abuse, which is kind of the stuff we talked about at the end of the first half of the semester: undue influence, unconscionable conduct, and duress. So we will continue on with that theme with both misrep and mistake, right? So it's what you'll see about mistake when Marcus takes the class is that it is a conceptually quite difficult area of law. Okay, it's arguably one of the more difficult areas in common law, and that's because it encompasses both elements of ending a contract or having a contract declared non-enforceable, but then it also imposes elements of the formation analysis. It goes to the heart of what does it mean for a contract to be formed. And so right at the outset, just to frame that part of the course, one thing you'll see is that a lot of the questions you have about mistake are not going to be answered satisfactorily because the doctrine itself is not satisfactory. It started off as a common law doctrine, and what happened in the 70s is Parliament decided, let's codify this doctrine. Let's try and add it into what was called the Contractual Mistakes Act, which has subsequently become part of the CCLA. Let's try and add some certainty to this doctrine. But what they did was keep the same level of uncertainty and possibly make it even more uncertain. So that's just kind of a precursor to what you're going to learn about mistake. Now, why I say all that is because I think it's helpful to conceptualize misrepresentation as a sort of cousin of mistake, if you like. Okay? Misrepresentation, as conceptualized in the Contract and Commercial Law Act, is the idea that you can end a contract because somebody has made a false statement to you, which caused you to enter the contract. And you will see echoes of this when you talk about unilateral mistake, which is one of the types of mistake that can lead to a contract not being declared non-enforceable. Because a unilateral mistake is when one party of the two makes a mistake, right? One party is mistaken about a particular fact, and that leads them to enter the contract. And so there will be quite a lot of overlap there when Marcus takes you, so I just want you to have that in the back of your mind. It can be that you would have multiple causes of action when you're bringing a claim, all right? That's quite common, as we've seen. So you could say that in a cause of action, you're bringing an action in misrepresentation to have the contract cancelled, but you're also seeking relief under Section 24 of the Contract and Commercial Law Act that the contract was procured by a unilateral mistake. The difference being that under the CCLA, there's limited difference. Because in both regimes, remember, all the way back to cancellation, you have the expansive discretionary regime of Section 43, right? And we talked about how that's really, really broad, allows the court to do pretty much whatever it wants. Well, that does apply to misrepresentation for the purposes of cancelling a contract. And under mistake, there's a similarly broad discretionary remedy. I believe it's 28 or 24, one of them, right? But so you can see how they're cousins. They're closely related. When misrepresentation leads to the cancellation of a contract, the court can impose a discretionary remedy. When a contract is procured by a unilateral mistake, the court can potentially impose a discretionary remedy if the requirements are met. Okay, so that's kind of the conceptual framing I want to give you. That misrepresentation is a cousin of mistake, but it is a distinct action in law. So just wanting to clarify that. Now, what we'll do this week, how we'll approach this week, is, as I said on Canvas, I'm not going to go through all the material on the slides. They're there for you and the readings. So I'm going to have expected you to do your own reading. Right? What I'm going to give you is the structural framework for how you apply these principles. And we'll do some interactive work. And my hope is that we'll get through the bulk of that today, so that on Wednesday we can do a bit of a summary of all the material that you and I have covered this semester, and some sort of very general exam revision tips. Okay, so that's kind of my hope, but we'll just sort of see how we go today. So there's a few things I want to cover. Firstly, by way of sort of preliminary matters, and that is the interplay between the two sections in the CCLA that deal with misrepresentation. Okay, one is Section 35, and the other is the one that you're most familiar with, Section 37. Okay, so we'll do that, and then we'll spend the bulk of our time on teasing out what is a misrepresentation. And the analysis that is in that third box there is material to if you were to apply it to a cancellation analysis. So if you were to go back and look at some of the scenarios that we've done under cancellation and see, is there a misrepresentation, then all those factors in the elements of misrepresentation under Section 35 would also be applicable under 37. There's one minor difference, but basically it's the same. Okay, so this is because they're common law or they're court-developed ideas or elements about what is a misrepresentation, and the wording is very similar in 35 and 37. So we can apply the same principles. So the first thing is that Section 35 is a damages provision. Okay, all it says is that if a contract was procured by a misrepresentation, or if one party entered into a contract because of a misrepresentation by the other party, then the defrauded party, if you like, is entitled to damages. And these are damages calculated using the common law damages principles that you learn in the first semester, so they're common law damages. The only thing the statute does here is it extends the common law damages framework beyond the breach of a term. So no term in the contract needs to have been breached for you to get these damages. You only need to show that there has been a qualifying misrepresentation. Okay? Two things to note about this. The first thing is, remember, Section 37 doesn't apply to the sale of goods, but Section 35 does. So if you have a sale of goods contract, you won't be able to cancel it under 37 for misrepresentation, but you can seek damages under Section 35. And the second thing to note, just as a precursor to what we'll talk about, note the phrase whether innocent or fraudulent. Okay? Because this is a really important point. When you think misrepresentation, what you automatically think is somebody lying or telling an untruth or a half-truth to try and manipulate somebody to do something, right? In this case, to enter a contract. What the Act says is that the misrepresentation does not have to be fraudulent. It can be innocent. In other words, you could be perfectly convinced that the thing you're saying is true. And it doesn't matter what you thought, it matters what was the reality of that fact. Was it true or was it not? If I'm selling you a house and I tell you there are no termites in the house, and I'm adamant and I think that there are no termites in the house, well, Section 35 tells us, and 37 will as well, that it doesn't matter what I thought about the termites, it matters whether the termites are there or not, in terms of whether you then have an action against me, either for damages and or to cancel the contract. So that's just a couple of points about 35. 35 is only about the damages arising from that misrepresentation. It's nothing to do with does the contract continue or not. Okay? Now remember, you can cancel a contract for a misrepresentation under Section 37. We won't go through that wording or that phrase again in 37. You can look that up. But there are some similarities and differences. Okay? The similarities are essentially the requirement for it to have induced party A, the defrauded party, to enter into the contract. And the wording of the two sections are very similar. Okay? Which means that we can apply the same common law principles or applications that the courts have used to determine, is this a qualifying misrepresentation under each of these sections. The differences are, as I said, that Section 35 is an action for damages. It's not about whether the contract ends or not, right? If you want the contract to end, you have to cancel it under Section 37. And most importantly, Section 35 does not require the representation to have been essential or for the untrue nature of it to have so substantially affected the bargain. Okay? So theoretically, this means that there is a broader scope of misrepresentation covered by 35 than in 37. I say theoretically because oftentimes it's going to be quite similar, but at least in theory, 35 does not require you to impose an essentiality or substantiality analysis. It just requires you to show the various elements of inducement, materiality, etc. Okay? So that is that's the comparison between the two sections. One of them you use just to get damages. One of them, if you want to end the contract and get damages and potentially other remedies under 43, then you would use 37. This doesn't mean that if you use one, you're not entitled to use the other, right? You can use both. Typically speaking, right, the court would usually just make the one award and take everything into consideration, but you're not prohibited from bringing an action in both. If you want to hedge your bets, that's perfectly fine, as long as it doesn't pertain to a sale of goods, in which case you could only use 35. And I've just got some authority there. I think it's the Court of Appeal or Supreme Court. One of them has actually cited the textbook as authority for the statement that any misrepresentation inducing entry into a contract is redressable in damages as if it were a term of the contract. So the court itself has granted authority to this statement from the textbook about that. So that's here, right? This is here. You need essentiality or substantiality. Okay. All right. So now what we're going to do is we're going to move to the elements of misrepresentation. What does it mean, using the words of the statute, for misrepresentation to qualify for damages or cancellation? Before we do that, are there any questions emerging from this? Nope. Awesome. If you have a question, please raise your hand. Now, so there are 6 things that you want to do when you're asking, is there a qualifying misrepresentation? Broadly, these will all apply to sections 35 and 37. There is one minor difference in the wording, but in substance, they will be very similar. I'll take you through that. Okay. The first is there is, in fact, a misrepresentation. So you've got to establish, is this a representation? Is it untrue? Okay, that's what you have to establish. Steps 2 and 3 are about, was it made by party B, right, or on behalf of party B, and then was it made to party A? So that's about the communication of the representation. Step 4 is about inducement. So did party A enter the contract because of the misrepresentation? And this is going to be quite similar to what you'll see in mistake, because a mistake must induce someone to enter into a contract as well. Okay, so as you can see, cousins, right? They're quite similar. Then step 5, you want to ask, is liability for the misrepresentation excluded or otherwise limited by a contractual clause? Now, you could probably do this one at the start, there's no right way to do it, right? This is just sort of a stepping through the life cycle, but it's not set out in law, so you're perfectly fine if you want to talk about exclusions prior to going through the substance. This is about, does the contract stop the court from assessing or making a remedial order in respect of a misrepresentation? Because remember, we have quite powerful clauses in the CCLA that protect contractual freedom or contractual autonomy. And then lastly, you're assessing what are the potential remedies for misrepresentation, which we've touched on a little bit, but you'll look at both the damages and cancellation remedies if relevant. Okay, so that's kind of the framework which we will approach. Now, the first one is about, is there a misrepresentation? And really, what we are focusing on is a couple of things, right? A misrepresentation, if we move past the authorities here, a misrepresentation first needs to be a statement of fact, okay? Right? It's a statement of fact that is untrue. Okay? That's a lay person's definition. Okay? Now, this requires a couple of things. One, it needs to be a representation, not a term. Okay? A representation is made outside the bounds of the contract. A term is within the contract. Okay? And frequently, if this is execution of the contract, right? Frequently the representation, actually almost exclusively, representations at issue will occur here. So the terms of the contract will be here, right? And the representations will be here. So, the first thing to ask yourself is, did the representing party intend that representation to form part of the contract? Because it may well be that they think that this should be within the contract. Okay? And this distinction is material for a couple of reasons. One, if it's a term, then it can be enforced. Okay? So that can be a straight-up breach of contract claim. But if it's just a representation, then the aggrieved party can't seek relief for breach of contract. They have to go and seek relief under the misrepresentation clauses. So it sort of weakens their position if it's not a term. And if it's a representation, you need to show that the aggrieved party was induced to enter the contract because of that representation. Right? You don't need to show any of that for a term. The term is there. If it's breached, then it occasions damages and possibly cancellation. Right? But you've got these additional steps, okay, to prove liability for misrepresentation. So it may well be advantageous to argue that to try and argue that this representation here was actually incorporated into the contract, which you'll discuss later in the semester with Marcus, but the courts have made a distinction between the two. So that's really the first thing you want to be asking. Is the statement of fact a representation, or is it part of the contract? Because if it's part of the contract, your action is in breach and potentially cancellation. But if it's a misrepresentation, then your action is in 35 cancellation, but also with some additional requirements like inducement. Now, if we go back here, these are a couple of authorities which you can cite. I've given you a couple of authorities. From the Court of Appeal, the representation must relate to an existing fact or a past event. Okay? And that really is this idea of a statement of fact. Okay? These other comments or obiter will relate to elements that we talk about later, but I just wanted to highlight that statement. The representation must relate to an existing fact or a past event. That will be material. Okay, so to illustrate a couple of examples, you've got two cases here. One is Couchman and Hill, one is Oscar Chess. And so I won't go through them in detail, but very briefly, what happened in Couchman and Hill is someone bought a heifer at an auction. The auctioneer made a representation or made a statement to the effect that the heifers had not been mated, right? And the purchaser subsequently finds out the heifer is pregnant, which devalues the heifer because the heifer delivers a calf and dies. Okay? And the question is that statement by the auctioneer a representation or a term of the auction contract, which contains several disclaimers, like you take it as you see it. We are not liable for that. Now, in Couchman and Hill, the court says this is a term of the contract. It's a modification of the contract because the terms were there at the auction site, and the purchaser goes up to the auctioneer and says, "Hey, are these heifers unmated or unserved?" And the auctioneer says yes. The court says that means the contract is modified to include a warranty or a condition about the nature of the heifers that are being purchased, which means the action is not in misrepresentation, the action is in breach of contract. Okay? So this is an example of where a pre-contractual representation is then incorporated into the contract. But in contrast, what you get is a statement from someone who traded in their car. Quite common, right? If you've bought and sold cars, you may have traded in a car. And as part of him trading in his car, he said, oh, the car was actually, manufactured in this year, 1945, I believe. They pay him a certain amount, and they subsequently discover that the car is manufactured much earlier, which would have meant they would have paid much less. So the question is this a term of the contract, or is this a representation, which would change the nature of the claim? In the first instance, they say, yep, this is a term of the contract, that the car was, this manufactured in 1945. And the court on appeal says, well, actually, no, this is actually a statement, right? Lord Denning kind of says it's a mistake, but then kind of comes around to the idea that it's actually a representation. To say that this was not intended to be part of the contract. It was a conversation, it was a statement, but it wasn't intended. Okay? So it seems like what we can derive is that intention is going to be relevant to whether or not something is a representation or something is a term. In this case, it was quite clear that he was an amateur with cars. Couldn't have been expected to have any formal knowledge about the nature of cars, right? All he could do was effectively communicate, look, I'm relying on this registration book in my glove box, and it says the car was manufactured in 1945. That's what I'm communicating, namely my belief that it was manufactured in that date. This isn't intended for me to communicate that I'm warranting to you the car was manufacturing in this date. I'm not binding myself to that statement. Okay? So that case illustrates that not all pre-contractual representations will then form part of the contract. Lord Justice Morris, however, disagreed. Lord Justice Morris said, well, that's kind of a central point of the contract, right? They're not going to pay that much for a car that they're not sure was manufactured in 1945. So Lord Justice Morris says, well, yeah, it's the subject matter of the contract. In these circumstances, it must have been intended to be part of the contract. Now, why do we mention this? I mention this because it will sometimes not be clear whether something is a representation or something is intended to be a term of the contract. If you are faced with such a situation, the best thing is to pick the strongest argument, right? Go down that route and then mention in the alternative, look, if this is not a representation, then it would be a breach of contract occasioning cancellation or damages under breach of contract, right? That would be perfectly fine to do, and that's normal, but it just goes to show that sometimes it is not clear which category it falls into. But it is important to make a distinction because that will determine what avenue you advise your client to go down and what avenue you go down when you're arguing before the court. Okay, so representations and terms is really the first distinction. You want to make sure you're talking about a representation that is not part of the contract, which allows you to have damages under 35 or cancellation under 37. But if it's a term, then breach or 37. So you can see how actually it might end up in the same place anyway, right? But the difference would be the difficulty in proving some additional elements for misrepresentation, potentially. I mean, and also that they're probably things like for breach of contract, you may have the obligation to mitigate your losses, those kinds of things. So that's just the distinction between representations and terms. Okay, now we've established that it's a representation, right? If we've established that it's a representation, then it needs to be untrue. Okay? So this needs to be a materially wrong statement of fact. The fact must be not true. It must be inaccurate. We're not talking about the degree of that or anything. It just is not true. Okay? Now, there are different types of statements which will not be qualified as a misrepresentation or an untrue statement. We'll go through a few of them so you can see the distinction, and so that when you see them in cases, right, you can be like, okay, this wouldn't allow me to go down the 35 or 37 route. I would have no cause of action for what this person said. Now, the first type is an opinion. Okay? And an opinion, okay, so here's the difficulty with these things, right? A lot of this is common sense. So we can derive some limited guidance from the cases, but a lot of it is common sense. So you will just have to make your best argument why you think something is an untrue statement of fact versus one of these other types of statements which wouldn't allow you to claim misrepresentation. So one example is in a case called Bissett and Wilkinson. Here, someone's selling land in the South Island for sheep shearing, right? And the representation at issue was the seller said this land can carry 2,000 sheep if only one team were employed in the agricultural work of the said land. So it's a statement about the capacity of the land for the sheep. Okay? The buyer says, I purchased this land on the trust that that was a true representation. Okay? Now, the court says this is, at first instance, this is an honest opinion. The Court of Appeals says, no, this is a fact, right? And so it goes to the Privy Council, which was the appeal authority before 2004 in New Zealand. Now we have the New Zealand Supreme Court. And the Privy Council says this is an opinion. So the Privy Council says, do you know what? The seller hadn't actually done any sheep farming on the land. They were just kind of speculating, right, that this is going to be able to hold these amount of sheep, right? It hadn't actually been used as a sheep farm, right? And therefore, the statement was just an opinion. So you can see the difficulty here, right? Because it's quite easy to conceptualize it in the alternative, that this statement was material, was part of the contract, was a term, and also it was a statement of fact, like this land can carry this many sheep. But the Privy Council disagreed. Privy Council says, however, that there's a reasonableness requirement to this. Okay? If a reasonable person with the vendor's knowledge, right, could not have come to the conclusion they stated, the description of that conclusion would not necessarily protect them against rescission for misrepresentation. Okay? What does this mean? It means if he said the land could carry 2,000 sheep, and it can't in fact carry 2,000 sheep, but if he looked at that land, he would automatically know it. Like anyone in his position with his knowledge could look at that land and say, there is physically no way 2,000 sheep could be on their property, right? If that is true, then the court says, well, that may take it into the realm of statement of fact that's not true, in effect. So something can be an opinion as long as it appears there is a reasonable, there's enough ambiguity or uncertainty for there to be different points of view about this thing. Like if you say something and it's just clearly untrue, right? Then that's more likely to be a statement of fact rather than an opinion. And I say more likely because, as we've seen, courts can diverge. Okay, so you make the strongest argument you can as to why this opinion, it's just an opinion. There are different ways to look at this, and this is just one way to look at it, which is being stated, which therefore will not ground a claim in misrepresentation. Now, confusingly as well, and this is again the law being ambiguous, but I'll try to bring some clarity to it. A statement of opinion by itself could actually imply a statement of fact. Okay? So, what you're trying to do if you're advocating for a client who is claiming misrepresentation is you are trying to identify a statement of fact that's being made by the other party, either directly or indirectly. So even if the defense is, well, no, I just stated an opinion, then the counter to that may be, well, yes, but your statement of opinion contained an indirect statement of fact. And we see this in a case called Smith and Land and House. Basically, this is a case where someone buys a property, land, on the basis that there's a tenant inside the property, right? So they have ongoing income. The problem was that the tenant proved to be not good, like didn't pay their rent, only paid when when they were pressured, that kind of thing, right? And it goes to court, and the issue is there that this is Lord Justice Bowen says, well, the statements of such opinion, the opinion being my tenant is a good tenant, is in a sense a statement of fact about the condition of the man's own mind. If the facts are not equally known to both sides, then a statement of opinion by the one who knows the facts best involves very often a statement of a material fact, for he impliedly states that he knows facts which justify his opinion. What does this mean? It means this. If I say that my tenant is a good tenant, right? My tenant is a trustworthy tenant. That's an opinion, right? But the opinion is underlaid by a statement of fact, namely that I don't have any reason in reality to question his trustworthiness, to question the tenant's trustworthiness or their ability to pay or their willingness to pay on time, etc. So just because you've got an opinion, it doesn't mean that you're automatically out of the race. You can try and find an underlying statement of fact. Okay? Now, this may well also depend on the position of the representor, right? Because if we go back to the sheep case, right? If the person knew a lot about sheep farming, right? Then potentially that will be relevant to that you're implying, even if you say you can carry 2,000 sheep, you're implying that you've got the expertise, that this land that there's nothing that indicates the farm can't carry 2,000 sheep. And in this case, there's nothing stopping the stopping the purchaser from buying a property where the tenant is a good tenant. So Lord Justice Fry says the vendors, by describing the tenant as such in substance that they knew no fact which showed him to be not to be a desirable tenant. Okay, so that's basically the idea, that if you are making a statement of opinion, you can be found to imply a statement of fact underlying it. So this is the difficulty of misrepresentation. You're trying to find some statement of fact that's being made. And this is, the flip side is also true. In a case called Ridgway and Grant, if the representor says something that is, they say it as a statement of fact, right? For example, hypothetically, this house definitely has no termites, right? But say the vendor has lived overseas for many years, has never set foot in New Zealand for like 25 years. They just own this property because, they inherited it from family or whatever, right? And they've never looked at the house. They don't know anything about it, and they tell you the house has no termites. The Court of Appeal has said that in such circumstances, it may be that that is just an opinion, which would stop you from claiming misrepresentation, right? When the vendor is not in a position to know the absolute correctness of a statement made. So the position of the representor works both ways. The more knowledge the representor has, the likelier that there will be some sort of statement of fact, either directly or implied. But the less knowledge that they have about the situation, then the likelier it will be just an opinion. And you'll find it more difficult to find a statement of fact underlying there. And it seems like that is designed to protect people, logically, from unduly being held liable for what they say, right? Think about it logically, right? What is contract law? Contract law is holding people to promises that they have made to each other. These are statements made outside the contract. So the courts and the parliament are saying, do you know what? The courts particularly are saying, well, let's tread lightly when we want to hold people liable for such statements, right? This is not, it's not to do with what's in the contract. So we want to just be a bit careful. We will hold people liable, but we don't want to be, too open about holding everybody liable for what they say. I mean, it's not going to be good for business. People can be too wary to enter into contracts. And we'll see later on how contract law practices or contract practice has developed to try and mitigate some of these risks. I've got a few examples of opinions and facts which you can go through in the slides. As will be apparent, a lot of these you could conceptualize it differently. Okay, so one in particular, a statement about that was a fact or implication of fact is in a case called Ware and Johnson. There they sold a kiwi fruit orchard, right? And there was a statement that said, there's going to be kiwi fruit on these vines in 2 years. And the court said, that is not just an opinion, nor is it a representation of a future state of affairs. Because remember what the court said all the way back in the Western Quayside Authority at the start of the slides, that it has to be a representation of a fact or a past event. But the court says here, well, that is a statement, right? That the vines in their condition were of such quality that they would produce a crop 2 years later. They were a representation as to the present state of the orchard. Now that's controversial, right? Because doesn't that open the door to every statement of like a forecast or something like that being a statement of fact? Potentially. So that this is where the difficulty arises and where your challenge is in drawing factual similarities in scenarios and then trying to argue whether or not there's a statement of fact or whether there's not. But I've given you quite a few examples there of both what's an opinion and what's not an opinion. So opinion is one, puffery is another. It's quite an old common law category. But puffery is basically hyperbole or exaggerations, frequently made in advertising or in advertising for products, right? So who's seen a real estate sign outside their house recently? Or not outside your house, but like, in surrounding streets, right? Anybody remember any statements made about the houses that you've seen? Like any particularly outlandish ones? Like, this is a real fixer-upper or something like that. You know what that's code for, right? This place is, just tear this thing down. Any others? Can you think of any other outlandish ones? Doesn't have to be real estate, but I thought real estate is a good example. Surely you've seen something outrageous said about a house or an apartment or something. What about not property? Just anything. Oh, sorry, I missed that. Yeah.
I've seen rooms advertised as spacious double rooms when it's literally the size of a double bed.
Oh yeah. So rentals.
Yeah.
Okay, so maybe let's bring it to rentals. What's some of the more outlandish descriptions of rentals? That's a good one. So spacious double bed.
It's like a spacious double room, but by double room they mean it could literally, like, you would have to climb onto the bed to get into a room.
Yeah, so spacious double room. Okay, yeah. So that's one. Any others for like rental properties that you may have looked at, or cars, or any other product that you can think of? So this tells me that product sellers and real estate vendors are lovely people. So yeah, but no. So the point I'm getting at is that oftentimes advertising contains lots of hyperbole, right? So you will have seen advertisements for cars, computers, washing machines, particularly those involving celebrities, right? That will endorse products. I've actually got a forthcoming paper with Professor Jody Gardner about how celebrity endorsements for, cryptocurrency, like cryptocurrency advertising, like that kind of stuff. Yeah, like that's actually quite problematic because people can end up with getting scammed and things like that. So, but the point is that those statements or exaggerations are likely to be considered puffery, right? They're exaggerations which no reasonable person could consider to be actionable or true. The fastest car in the universe. I mean, really, right? Like, and the thing is, the line can often be difficult, and there's liability in other areas of law which you're not expected to know. So under the Fair Trading Act, you're not allowed to engage in misleading and deceptive conduct, Section 9. So if you're interested in that, go do consumer law with Jody Gardner. But when it comes to misrepresentation, puffery will stop you bringing an action for misrepresentation unless it's about a statement of fact, right? So these exaggerations will not ground a claim in misrepresentation. A more contemporary illustration than the ones I've got there is in a case called Closure Pack. There you had statements made about some equipment, like factory equipment, I think. And the High Court says there that when the statement was made that the equipment was excellent, right? The argument was, oh no, that's puffery. That's a defense. I'm not making a misrepresentation. I just exaggerated, hyperbole, like nobody could reasonably expect that to be true or that statement to be a statement of fact. The High Court says, no, that is a statement of fact, right? It wasn't puffery, it was a description of how effective the machines were given their age and state. So the context matters, and ultimately it will turn on the facts whether or not you consider this is an exaggeration or hyperbole or something that shouldn't ground a claim of misrepresentation. It's too much of a hyperbole. It's nonsensical. It's clearly designed as exaggeration and hyperbole, not to be relied on. Okay, so that's not going to be a not covered. That's not going to be covered. Alrighty, we will take a break in a few minutes. Then you've got a few others, which I'll just. Oh yeah. So statements, law, half-truths, gotcha. Okay. So another one to add to the confusion. Okay, so this is even more confusing. Statements of law. The court does not allow you to claim misrepresentation against someone who made a statement about the law or a legal position. That's the rule. And the logic there seems to be that the law or legal positions are not really things that people can reliably comment on, with any absolute certainty. The law is variable, right? There's different opinions on it. So we can't allow claims of misrepresentation on the basis of something so uncertain. So this can include statements about the law or the application of the law, right? For example, you definitely don't need a resource consent or a building consent to, tear down your house and build a new one. Okay, that may be an outrageous statement, but it's a statement about the legal position. It's about the application of the building laws to your particular situation. So the court says that's not going to ground a claim of misrepresentation. The one exception to that, again, is this idea that the statement of the law might imply a statement of fact, right? It might imply a statement of fact that you have enough expertise to make that claim. Secondly, the court in O'Dale and Lawson has said that if you make such a statement, right, that a building consent is not required to tear down your house, but you don't actually think that, you're saying something that's different to what you actually think. Like, you need a building consent. Like, that person needs a building consent. If you then tell them they don't need a building consent, the court says that is a misrepresentation of fact, because a misrepresentation can be as to the state of somebody's mind. So if you say something, if you say, I think X, but you actually think Y, then it doesn't matter if you were giving a statement about the legal position. It matters that you are misrepresenting what you thought, and the other person relied on that. Okay? So, confusing, right? The rule is that if it's a statement about someone's legal position under the law or the application of the law to their situation, then that's not covered. But if that statement implies a statement of fact, for example, as to expertise or to your actual mind state, then that may cover, that may be covered under misrepresentation. All right, we'll go for a break at 12. So a couple more minutes. I just want to cover these two more. So I will go to failure to disclose first, and then we'll go to half-truths. So failure to disclose is controversial because it means that half-truths here, rather. Non-disclosure, we'll call it. So a non-disclosure or silence is not covered by misrepresentation. That's the foundational idea. So just because somebody is silent, that will not ground a claim of misrepresentation. There needs to be some sort of positive communication towards the other party, right? Because silence could mean so many different things. There's not enough certainty to ground a claim of misrepresentation there, right? And it opens the door to, well, you inferred all these things from the silence, but actually that wasn't the truth. But that is, again, qualified, right? It's qualified by, but maybe half-truths may be covered. So if you say something that's half-true, you disclose some things but not the other, then that could be liable. So you could be liable for that. You've got a few cases there with that authority. Essentially, it's not telling the whole truth, nothing but the truth, right? You're omitting some facts. That could, what the textbook says, is distort a positive representation. So the idea being that in failing to mention these things, you are changing the nature of what you're communicating. Okay? So that one of them is half-truths. Another one is failing to disclose a change in circumstances, which is which is the case when you have like a long period between the contract is signed and then the contract is like completed, right? Just because you're silent, then that doesn't necessarily that doesn't necessarily stop you from stop you from suffering the misrepresentation claim. Okay, so again, this is before execution, right? So initial discussions are here, and then execution is here. And if something changes at this point, and you don't disclose it, that silence could still ground a claim of misrepresentation. And again, it's this idea that there was a representation made in the first place. You've just changed it by failing to disclose this material fact. And Walsh and Kerr is an example of that. Also, failing to correct a misconception can ground misrepresentation. So if you know something and during, say, a conversation about a potential property sale, the purchaser is like, oh, yeah, I'd love to do all these things on the property. I'd love to, like, I don't know, build 15 million. It's like, I'd love to build a lot of apartments on this property, right? And you know, actually, that the land is really soft underneath and it's not going to hold those buildings, but you don't say anything. The court says, well, that kind of silence could potentially ground misrepresentation. So the authorities are there. You can have a look. Let's take a break now, and we will come back at 12:10, and we'll continue on with the other elements of misrepresentation. I'll be down here for questions during the break if you have any.
I think that's kind of because the court did say like hadn't been used in that way. Yeah. But you're right; it does seem to indicate sort of something. So had that been made, a lot of the judgment here on what the parties make most of them in that case. I don't think they most of that. Yeah.
Okay. Thank you. The other thing I was going to ask was with O'Dale and Wilson.
Yes.
It's not about the same as law, it's about the trust or practices.
Yes.
Does that mean that, like, if you make a statement about the law and I'm relying on the fact that you're my lecturer, I'm going to blah, blah, blah.
Yep.
The thing that induces me into a contract, for example, has to be the faith I put in you, not the statement itself. So you'd have to prove that.
Yeah. So it would be not so much the faith, but more so my statement that I think this is true. This legal position is true. So if you're having a conversation with me about am I entitled to purchase this property, and I tell you yes, I think that. Yeah. Right. Now that's a statement about the law. But if I actually don't think you're entitled, and I just said that for example, you're buying from my cousin, and that would benefit me, right? Like that's. Yeah. The qualification is, however, that misrepresentation is typically as between the two parties. situation, an indirect statement, that's probably going to be more like a mistake analysis. Because you're not entering the contract with me. It's different if I'm selling my property, right? But if you're buying it from somebody else, then it's probably going to be unilateral mistake or some other mistake, which would elaborate very similar evidence, but just different course of action. Yes.
That, it might imply that that person making the opinion had something to base the
Yes.
that's the fact.
Yes. Yes.
You used an example of that tenant relationship.
Yes.
They imply affiliate example.
Yes.
So it's just, does that mean if the tenant is like actually listening, like
Yep.
sometimes being
Yep. Yep.
they represent anyone,
Yep.
that's not a misread because people are
Yep.
factually
Yeah, correct. Yeah, you're correct. Because this is why it's important to conceptualize the misrepresentation, right? So let's say I'm the purchaser. I'm buying the property from you, right? And you're saying your tenant's great, right? Then obviously the tenant doesn't represent me. Now, if I claim misrepresentation, right? And I say you misrepresented, your defense would either be number one, that was just my opinion, right? Number two, if it does imply a statement of fact, all it's implying is that I did not have any knowledge. And that statement is still true. So, because that statement is true, we wouldn't ground a claim of misrepresentation.
and look at the legal position and use the example of like this house is on the
Yes, yes.
Isn't that a bit hard to distinguish what's the fact? Because on the one hand you could be saying I'm representing the law as it applies to this house as being good. But on the other hand you could say I'm saying nothing about the law. I'm applying that the building asset
I mean, potentially. I mean, I'd probably say that any issue of consent, any issue that involves the application of a standard by a governmental authority, it's likely to be a legal issue because the council is going to be saying the one who says to consent, right, or the legislation of the building commission. That's what's going to be indicating the legal issue. But absolutely, right? Like you could certainly argue that. It's different if you're saying this is not the type of building that is historically required a building consent. That's different, right? So that could be a statement of fact, right? If you're saying that, yeah, and where that line is, nobody knows. So that's why this category, in my view, are not stated. So that's kind of difficult. Yeah.
Actually, my question was a bit related to
Oh,
what
yeah,
you were
sure.
saying. So, would the courts take into account, for example, if a lawyer was selling a property, but they're not, their specialty wasn't exactly in whatever they were like stating in the law?
So what I'll clarify is that misrepresentation is as between the two parties. So it's typically when you go to a lawyer, right? You're going to a lawyer to go and buy property from somebody else.
No, like between.
Between the two parties.
Yeah.
So if you're buying from a lawyer,
Yeah.
right? So number one.
Would the courts impede like the duty to have known something?
Yeah.
For example, let's say it's a family lawyer,
Yeah. Yes.
and then I'm buying a property from them.
Correct.
And then he makes a statement of law that is incorrect.
Yeah.
Would the courts like impute a duty of like they should have known?
I see.
Because he's a lawyer, or would
No. They wouldn't. So there's a broad exclusion statement. But him being a lawyer may well go towards it being likelier that he knew what he was saying. You see what I mean?
Yeah.
Like it's still relevant. You're just not going to impose a duty necessarily. But in practicality, your range of action would be probably yeah. It could be misrepresentation, but if it's statement of law, then it could be So all of these things are not misrepresentation. Yeah. So all of these things are not.
Oh, okay.
So non-disclosure, recovery, opinion, they're theoretically not, right? But then there's all these caveats.
So even failing to disclose is not.
Silence. Yes, silence is not misrepresentation. But maybe failing to disclose is maybe failing to provide, maybe a half of it. I say maybe because it depends on what the court will argue ultimately. But these are the kinds of things where they have said there are exceptions to the idea that silence cases haven't indicated just no. But the other ones, yes, they do. No worries.
All right, let's continue. Now, I do have some scenarios. So what we'll do is we'll go through all of these, and then if we have time, either today or on Wednesday, we'll go through at least one of the scenarios, and then I'll put the scenarios and notes up on Canvas. So steps 2 and 3, if we go all the way back to here, remember there's 6 steps. Steps 1 and 4 are the 2 most meaty steps. Okay, they are the ones with the most material and the most, with the most uncertainty. Step 2 and 3 are relatively simple, right? They involve the communication of the misrepresentation. So you've got party A and party B, and the misrepresentation is going this way. Okay. Now, what's happening under here is that the word says it has to be made by and to, under 35 and 37. So the statement has to be made by or on behalf of the misrepresenting party. And this just highlights another point here I wanted to clarify. Misrepresentation is an action as between 2 contracting parties. Okay, so you always have a contract between these 2. And the question is, does the misrepresentation lead to the that contract either being cancelled or damages being available? Okay, so if someone makes a representation and you go and enter into a contract with a third party on the basis of that, that is more likely to be a mistake issue than it is about misrepresentation. Okay, so just wanted to clarify that. Third-party misrepresentations are typically not covered under these causes of action. All right, so very simply, we'll go through by and to quite quickly because we'll go to inducement. By and to are about who made the representation. Okay, so either if it was made by, it was made directly by A. Okay, in which case there's no issue. You can just say the statement was made by A, move on. Nothing there. The issue is when it arises indirectly. So if there was a mediator between A and B in terms of the representation. So in that instance, the question becomes, was the statement within the authority that A gave C? Okay? So here's the statement, and here's the authority. Okay? If the statement was within the scope of the authority, then A will be bound by the misrepresentation. But if it was not within the scope of the authority, A will not be bound by it. So the question is going to be, what was the scope of the authority? And you can probably you can infer that by, by the facts. What did A engage C to do? Commonly, this is the case with real estate agents. Like when you engage a real estate agent to sell your house, what are you asking them to do? You're asking them to make representations to potential buyers so that buyers will like your house and be attracted to it and then potentially make offers to purchase the house. And in that instance, it's arguable that the authority is quite wide-ranging. You give your agent the authority to make all sorts of representations about your house in the hope that that representation will lead to a sale. But the representation cannot arguably be false or illegal or anything like that. There's probably you're not giving authority to your real estate agent to make that representation, right? So the authority will not be absolute, but it can be wide-ranging. The facts will indicate the scope of the authority. So that's really the only situation in which this requirement will become controversial. Okay, if a statement was just made by A, right, that's perfectly fine. You can just skip, you can just move on. But when it's made through an agent, then the issue is what's the scope of that authority, and does the statement fall within that scope? The statement being made to the injured party is similarly straightforward if it just went straight from A to B in a conversation or an email or whatever, right? Like that again is non-controversial. You wouldn't need to spend any time on it. The only time this arises is if the representation is made again through an agent, or it's made like broadly. So it's not made just to C, but for example to all persons who might fall within the class of C. And so the court in Baker and McKechnie has said that if you're part of like a class of people to whom this statement was advertised, then that could meet the requirement of 2. And also, if you make a statement to one party, and you intend for it to be communicated to the other party, or you know that it will be so communicated prior to the contract, then that can also be covered. So the bottom line is that it's going to be quite broad, right? The fulfillment of this requirement. Basically, anything that you say, if you're a representor, and you make it, even if you make it indirectly, there's a good chance that you'll satisfy the 2 requirement. Okay? Now, quite minor point, if we go to the Contract and Commercial Law Act, and we look at sections 35, right? So what do you see here? Made to A by or on behalf of another party to that contract. So 35 does not include the requirement for made to that party. Okay? Whereas 37 does. See? A party has been used to enter into it by misrepresentation, made by or on behalf of another party to the contract. It's one of the others. Here, sorry. Oh, there we go. Sorry, my bad. 35 contains a requirement. Made to A, right? So this is a requirement for section 35. It's not a requirement for 37 because all it says here is the party has been induced to enter into it by misrepresentation, whether innocent or fraudulent, made by or on behalf of another party to the contract. Okay? So theoretically, the 2 requirement does not need to be shown for section 37. However, it's most likely going to be non-controversial. If it is going to, or if there is any doubt as to it, then you could potentially say that you're not entitled to damages under section 35, but you would still have an action potentially under section 37. But in my view, that is going to be quite rare. It's certainly never arisen in the cases that I'm aware of. But just pointing out the legislative drafting quirks that can lead to differing outcomes potentially. So it seems like there was just a quirk there in the drafting, but important because that is the law. So we need to note that. But this requirement is likely to be applicable for both. All right, so we've got, is it an untrue statement of fact? And was it made by or on behalf of A? Was it made to party C? Party B? And then we go to, were they induced to enter the contract? And inducement really is one of the main things, if not the main thing, about misrepresentation. Okay? So inducement covers, what have I written down? Yep, all right, cool. So inducement comprises a few things, right? Inducement comprises knowledge, reasonableness, and intention, and materiality. So 4 things about inducement that the cases reveal to us. Okay? Knowledge is twofold. Knowledge is, first, did B know about the misrepresentation? So were they aware that that statement was there or was made? Right? Because logically, if you don't know about a statement, you can't be induced to enter into a contract by that statement. Right? That is reasonably common sense. And the test is from a case called Leeds City Council and Barclays Bank. It's British authority, but will still be persuasive in New Zealand, arguably. The test is the representee, the person who has received the representation, is it actively present to their mind? So that's the test. Can you show that it was actively present to their mind? If so, that will ground a claim in misrepresentation. If not, it won't. So they need to know about it. But if they don't, if they know that it was untrue, then they can't get relief for misrepresentation. Okay, so here it will say probably don't know it's untrue. But if they know it is untrue, then they're not going to be allowed to claim misrepresentation. This needs to be actual knowledge. Okay? And Nocton and Lord Ashburton gives us authority for that. No one is entitled to make a statement which on the face of it conveys a false impression and then excuse himself on the ground that that person to whom he made it had the available means of correction. In other words, you can't get out of a claim of misrepresentation against you by saying, well, they should have corrected the record for themselves. Right? That's not on the victim or the defrauded party. That's on you. The only way you get out of it is if the other party actually knew the statement was untrue. So, for example, if I tell you that the house doesn't have termites, right? But in fact, you know that the house has termites, and you go ahead and purchase the property anyway. You can't later turn around and say, well, you made a misrepresentation to me that the house didn't have termites. Because I will turn around and say, well, you clearly knew. You got a report from a pest control expert that there were termites in the house. You knew. You knew that this wasn't true, and you went ahead with it anyway. And logically, that's because of the requirement of inducement. You need to be induced to enter the contract by misrepresentation. So if you know something is untrue, then logically you can't be induced to enter into the contract because of that untruth. So that's knowledge, number one. Reasonableness is also has a couple of sub-elements. One of them is a reasonable interpretation. So, does B reasonably interpret the statement that has been made? Okay? For example, if I tell you the house does not presently have termites, is it reasonable for you to interpret that as the house has never, ever, ever, ever in the history of its construction ever had termite infestations under any vendor, past or present? Probably not. Right? The nature of the statement is as to one vendor's experience and the current state of the house. It has nothing to do with whether or not the house had termites or not in the past. Right? So that is an example of what would be an unreasonable interpretation of a statement, which then goes to that didn't induce you to enter the contract, right? You need to take a reasonable interpretation in all the circumstances, and you can cite Western Quayside for that. So reasonable to interpret, and then reasonable to rely on that statement. Interpretation, reasonable reliance. Okay, so did you take a reasonable interpretation of the statement? Was it reasonable for you to rely on the statement in the way that you did? Okay? So Vining is your authority for that. And Western Park gives us a good test. If no reasonable person in the position of the purchaser would have relied on the statement of the type given, it would be a rare case in which the misrepresentation could be said to have induced the purchaser to buy the property. So the test is a reasonable person in the purchaser's position. What would they have done? Would they have relied on the statement that there are no termites from the vendor to purchase the property? And if they did, then that's fine. But if they didn't, like this house, is clearly, it's common knowledge that these types of houses are notorious for termite infestations, and they most likely have termites, all across the country, all of those kinds of things. If a reasonable person would have that knowledge and would not have purchased the property on that basis, then it's unlikelier that the claim will be made out for inducement. So you've got knowledge, you've got to know about the misrepresentation, it has to be actively present to your mind. You've got to know that you've got to not know that it's untrue, right? So you've got to believe that it's true. You've got to take a reasonable interpretation of it. You've got to, your reliance on it has to be reasonable. And then it has to be material in making you enter the contract. So materiality is about causation, right? It's this idea that the representation, there's a causal link of some sort between the representation and your decision to enter the contract. So the authority for that proposition existing is in Saville and NZI Finance. It's not in the statute, but it has been accepted by the courts as a continuing principle from the common law, or rule from the common law. Okay? And it's quite a broad category. In Mount Pleasant Estates, Justice Tipping has stated, and this has been approved by the Court of Appeal in Vining Realty, that in most cases, entry into a contract is not a single discrete event, but a process whereby terms are negotiated and conditions are fulfilled. Any misrepresentation materially influencing a party along that continuum is, in my view, being capable of being a misrepresentation inducing that party to enter the contract. So what Justice Tipping is saying is this, right? Here you've got the parties meet, right? And here you've got they execute the contract. Here is the negotiations, right? So Lord Justice Tipping is saying anything along anything here is potentially able to be material. So it's quite a broad view of what is material. But it does need to have a certain weight, okay? It can't be of such little weight that it's just not that important to the purchaser, okay? And whether or not it's important enough will depend on the facts. But one example could be, if I tell you that the house has no termites, right? And you buy the house from me. Now, same representation. But if you are a person with a family of 5 who intends to live in that house for the next 30 years, right? That's your forever home. Versus you are a developer who intends to tear down that property, raise the place, subdivide the lot, and put up 12 apartment blocks. Okay? Now that's different, because to the first purchaser, the representation is like really, really important that it has no termites, right? Because you want to live in there, right? Like that's important. To the second purchaser, it's of less importance, right? Because they're going to tear the house down anyway. So what does it matter that there are no termites? Why should that statement allow the developer to get out of the contract? Because statements about termites didn't really make you want to buy the property. You bought the property because of the location, because of the value that you could get by subdividing, tearing down, and building apartments. You didn't get value from the house not having termites. So that's an example of the fact that there needs to be some sort of weight or importance to the influence that the representation had on your decision to enter the contract. And also, there's a further qualification which has been approved, which has been indicated in the High Court in 2014, that if you get independent verification of the representations, right? Like, say I get a builder's report, or say you get a builder's report, and that tells you, or a pest inspection report that tells you that there are no termites in the house, right? And then there subsequently are termites in the house. Well, you can't bring an action against me for misrepresentation because you got your own independent verification of the representations, and your issue is with the pest control report, not with the vendor. And that's what Penny and Burns and Ng are saying there. Okay, the plaintiffs were aware of the plaintiffs had relied on a building report, not on the vendor. So that's materiality. It needs to have some sort of causal connection. And the last requirement is this idea of intention. So again, there's this it's an authority or rule from the common law that's been applied to the CCLA, and we've got authority there from Saville. The court has indicated that previously wasn't the case, but we need intention now. And crucially, this is the point. The intention is not to mislead. Because remember, a misrepresentation can be innocent or fraudulent. It doesn't matter that you had no nefarious or malicious intent towards the victim. The intention is to make them enter the contract, whether or not you knew that the representation was false or not. So that's what Saville says. The representor must have intended to do so or willfully use language calculated or of a nature to induce a normal person in the circumstance of the case to act as the representee did. So you need to look at the actions of the representor and say, does the statement that was made appear designed to make the other party enter into a contract? Which is quite normal in negotiations. You want to put your best foot forward. You want the other party to enter into a contract with you that has desirable terms, right? And so that's likely to be, quite, not straightforward, but there's going to be quite a broad attitude applied to that. Okay, so the distinction would be if this was like a throwaway statement, right? That it wasn't made in the course of negotiations. It was just, something that the vendor just said. Right, and the purchaser took on that and really relied on that. Well, the court is saying, actually, for that reason, we don't want to unduly penalize the representors or contracting parties for every statement that they make. The statement needs to have some sort of intentional quality about it to make the other party enter into the contract. And if that's the case, then that can ground a claim for misrepresentation if the statement is subsequently shown to be false. So inducement, the requirement to induce party B to enter into the contract, requires 4 things to be shown. 1, party B needs to know about the misrepresentation. They can't know that it's untrue, right? Then they need to Number two, there needs to be reasonableness in both reliance and interpretation. Number three, it needs to be material. In other words, it needs to be a significant cause of them entering the contract. Doesn't have to be the only cause, right? Remember, I think from some of the other material that we've studied, but it does need to be some sort of significant cause. It can't be irrelevant. It can't be immaterial to them. It needs to be some sort of significant influencing cause. And there needs to be an intention from party A that the statement they made would encourage or induce party B to enter the contract, whether or not they knew it was false. That part is irrelevant. Any questions thus far? Anything unclear? 12:35. Good, we are making good time. So what I'm going to do is I will leave you to see how those principles apply in Edgington and Fitzmaurice, and Saville and NZI Finance, because one's an older case, one's a newer case, but they both deal with the application of misrepresentation. And so you can see how these principles will apply in those cases. Now, what I want to do is I want to go to step 5, which is the exclusion, right? Exclusion/limitation. Now, there are two contractual provisions that we will look at here. Let's go back to... So remember here, and I'm going back to the legislation because I want to always, I want to drill into you that in practice, always go back to the source material, right? Don't rely on secondary material solely. That will not go well for you. Go back to the legislation, go back to the cases, identify, what the law is. So section 34, remember, says if a contract expressly provides for a remedy for misrepresentation or breach of contract, or makes express provision for any of the other matters to which sections 35 to 49 relate, those sections have effect subject to that provision. Okay, so what is this? Section 34 is this broad contracting out or contractual amendment provision. Basically says that if you want to amend anything in the way that 35 to 49 work, you can do so by contract. As long as you guys agree, then that's fine. Obviously, it doesn't stop you if there's undue influence or whatever from claiming that as a vitiating factor, but short of that, the contract will prevail. So this is really important. So always ask yourself, is there anything in the contract that changes the requirement for a misrepresentation claim? Because that will be upheld under section 34. Okay, so that's the first one. And the second one is in section 50. So if we go down to section 50, you'll see here that section 50 is a counterbalance to section 34. Because section 50 says that if a contract contains a provision purporting to prevent a court from inquiring into or determining the question of whether a statement or etc. was made, whether if it was a representation or a term of the contract or it was relied on, then the court is able to bypass that provision if it considers fair and just to do so, or fair and reasonable to do so. Now, we'll go through that after this, but I just wanted to show you the provision. So let's first look at the contracting out provision. And the general approach you want to do is there anything that amends the misrepresentation criteria, whether it's as to the criteria you need to show for misrepresentation, or as to the damages or the remedies available, or as to whether or not whether or not a misrepresentation claim can exist at all. Okay. So you could contract out here entirely of liability for misrepresentation. Like, that is possible. The courts might say, the parties might say, the provisions of sections 35 and 37 of the CCLA and all related provisions as to the cancellation of a contract for misrepresentation or damages for misrepresentation do not apply to the parties. We will regulate our own damages in the event of misrepresentation. Right? That's perfectly fine to do. That's a version of liquidated damages. Like, that's perfectly fine. Right? The court will uphold that. So you can contract out. You can also limit liability. So you can say that if representations are found to be untrue, right, then the liability of the representor will be limited to X, Y, and Z. Again, a version of liquidated damages. And the logic there seems to be that the court is allowing the parties to have certainty as to what will happen if there's found to be a misrepresentation. Typically, if there's a contract involving a power imbalance, like a significant power imbalance, then that's going to disadvantage the weaker party, because it may well be that they are signing up for a reduction in what they could get for remedies-wise for a misrepresentation. But you're allowed to do that. Okay? So there's a couple of authorities there for that. And then what we have is this idea of the entire agreement clause, which is slightly different because it focuses on the criteria for misrepresentation rather than the liability arising or the remedies arising from misrepresentation. Because for these two, right, they kind of focus on, they don't really care if the requirements for misrepresentation are made out. What they care about is saying, even if they're made out, then there's either no liability or only some liability. Okay, so they're focused on the liability. Entire agreement clauses are focused on the substance. Entire agreement clauses say, this agreement is the entire agreement between the parties. No reliance is placed on any representations made, either verbal or written, before or outside the contract. Okay? And what that clause is doing is saying nothing induced the person to enter the contract except what is in the contract. So we'll look at an example of what an entire agreement clause looks like after this, but that's the broad idea, that there is no claim to be made by someone saying, well, you said this before we signed the contract. That clause says that's not relevant. That isn't, you've acknowledged that you did not rely on anything outside the contract. You only relied on what was in the document to when you read it and you said that is it. Okay? Now, the logic behind that clause, again, is this idea of certainty. Right? It's this idea that rather than allowing parties to fight about what was said before and after a contract, it's creating certainty to say, you know what? The only thing that is going to be disputed is within the four walls of the contract, the terms. So that's what an entire agreement clause does. However, the entire agreement clause is subject to Section 50. Not these clauses. These clauses are not subject. Okay? Exclusion of liability, limitation of liability, if they're there, then they will be protected. Right? Because they're not about what Section 50 sub 1 is talking about. Whether or not a statement was made, number one, whether it was a representation, or whether it was relied on. Liability has nothing to do with that. Liability is what happens if there is a misrepresentation. But if there's an entire agreement clause, then the court can look beyond it. The court can bypass it. If the court considers, the court is not prevented from doing so unless the court considers it is fair and reasonable for the provision to be conclusive as between the parties, having regard to the following matters. All the circumstances of the case, number one. That's everything, but it includes these three things, right? Subject matter and value, bargaining power, and representation by a lawyer. Representation or advice by a lawyer. So all the circumstances of the case is an invitation for you to argue on the facts. You've got to persuasively argue why this clause is a fair and reasonable clause to stop somebody claiming misrepresentation. And you have to show why it's fair and reasonable relative to these three things. Now, we'll look at a couple of cases that deal with that, but instinctively, again, I want to keep pushing on this idea that you've seen throughout the semester, that on the one hand, we believe two parties are sophisticated parties who have entered into a contract and therefore the state should not intervene, that courts and parliament are not going to intervene in what the parties have agreed, the substance of their agreement. If you want to sell me your car for $1, then that's on you, right? As long as there are no vitiating factors. But here, Parliament has said the court is able to consider whether a clause is fair and reasonable, right? Now that remains a tension. Why should the court be able to assess what two parties have agreed to? And why does the court get to decide whether that's fair and reasonable? So no answers there. It's just an ongoing tension that you have seen and will see throughout the rest of the semester. This is obviously limited. The Supreme Court has told us that we are not talking about a general determination of the true bargain. So the court is not evaluating, is the entire contract fair? Like, that's not what the court is doing here. The court is asking, is it fair and reasonable for that particular clause to be conclusive? That is it fair to stop one party from claiming misrepresentation because of this clause? That's essentially it. Okay, so that's your authority for the scope. Two cases. One of them is Brownlee, one of them is PAE. In Brownlee, the clause is there. The purchaser acknowledged that it has purchased the license solely in reliance upon its own judgment and not upon any representation or warranty by the vendor or any agent of the vendor, and the vendor does not warrant the accuracy of any matter or fact herein, etc., etc. Okay, so you can see how this is different from an exclusion of liability. Right? This is about substance. This is about what statements were made and relied on prior to the agreement being entered into. It's not about whether or not the liability is excluded or limited when it comes to misrepresentation. And the court here says, or the Court of Appeals says, well, this is fair. This clause is fair. It should prohibit misrepresentation claims. The court says it is highly desirable that we need these clauses to avoid the uncertainties which can arise from allegations of verbal representations or collateral warranties, right? Which is what I said before. You need certainty to stop parties flinging accusations at each other that you said this and you said that and I relied on what you said. Okay, so the Court of Appeal gives us the rationale for this type of clause. Now, for this particular clause, then, the question becomes, is it reasonable? And the court says, yes, it is. Okay, so you had two parties. They were both commercial parties. This was a purchase of a business, right? They both had separate legal advice, so they were all advised by lawyers. This was a big enough transaction, right, that you can expect the parties to be familiar with the terms of the agreement and the intention to be bound by them. The idea that, the more weighty the transaction, the more care you're going to apply to to due diligence. And if you are intending on going into a commercial law firm, right, and applying for clerkships and going into work in mergers and acquisitions, banking and finance, etc., then a large part of your job is likely to involve due diligence of documents from companies that are seeking to merge or take over other companies. And the reason for that is so that you're not surprised, that you don't see something buried in the financial statements that could have grounded a claim in misrepresentation. Okay? Now, sidebar, I don't think your jobs will be replaced by AI in that regard. But I appreciate the tension there, because there's this is just my hobby horse, but given I don't have much more time with you guys, I thought I'd give you my opinion. There's a tension in the discourse. On the one hand, there's a lot of discourse in favor of, AI is going to transform the legal profession and it's going to X, Y, and Z, right? It's going to, essentially help senior lawyers not hire junior lawyers, which I appreciate creates, some worry and anxiety. On the other hand, I would give you some encouragement comes from the judges, actually. A lot of judges, not all of them, but a lot of judges are the ones who are saying, no, you know what? We really need to take a second look at the way that AI is being used in the legal profession. We need to re-emphasize the fundamental duties of lawyers and the idea that you stand behind all the work that you do. Okay, so you will have to navigate a tension between technological proficiency and the idea that I'm doing a special law and technology class on Wednesday, so I'm talking more about this stuff there. But the idea that the legal profession has existed for thousands of years, literally. Advocates have existed for thousands of years. The task of the lawyer has not changed. Doesn't matter if there's AI, doesn't matter if, it was the same with any other technological innovation. So your job is not to be, how can I be the best AI-powered lawyer? No. Your job is to be, how can I be the best lawyer as a person? The quality of my brain. How can I be that? So that's just, my encouragement. Don't know how I got there, but when we go back to these types of clauses, you will do due diligence, but those contracts will also include these types of clauses there, largely, between commercial parties. Court says, that's fair. You intend to be bound. That's all good. Nothing in there suggests we need to change anything about it. The circumstances don't suggest that. Clause is fair and reasonable. You were advised. And, tough luck. PAE is an interesting, more recent example, because in this case what you had was a purchase of a business, right? They purchased some shares from a directors of a company for about 1.25 million. And 2 years later, PAE, the purchasers, said, you, the directors, misrepresented during the negotiations. The contract, however, included an entire agreement clause. Not going to read the whole thing out, but it basically is quite similar. Okay, so there's no reliance on statements, no substantive, nothing substantial outside the bounds of the contract. So in the first instance, there was misrepresentation, yes, but the issue wasn't whether or not there was misrepresentation, but whether or not the exclusion clause protected the directors from liability. So it goes to the Court of Appeal. You do have some statements here about what the point of the Section 50 is, to protect one party's vulnerability to another, right? To allow people to bring actions and to not lock away their right to seek recourse. So that's a good statement of the authority, but let's go to what happened, because I think that's quite interesting. So the court has to decide, is this clause fair and reasonable? Should we uphold it? And the court said, actually, we should uphold it. We should uphold it because PAE is the one who's claiming misrepresentation, right? But they were the ones who drafted the contract. Like, their own lawyers prepared this clause in the contract. So it would be disingenuous for them to then turn around and say, do you know what, we drafted a clause that would protect us, but actually we don't want to give you, the other party, the same protection. right? You can't have it both ways. If you want a clause like that, then it has to protect both parties. Further, PAE had every opportunity to require contractual warranties within the terms of the contract. If they really needed these things to be certain, then they had opportunities in the negotiations to specify, we need this put in the contract, that this is true. And they said that PAE was actually stronger. They were a multinational company, experienced in takeovers and acquisitions, etc., and they had independent financial and legal advice. Okay? And so the court says, well, we shouldn't allow you to get out of this just because you didn't do your due diligence. Alrighty, well, we'll leave it there for today. We're nearly at the end of MISREP. So we'll finish off MISREP on Wednesday, and then we will do a little bit of summary of the whole course thus far and a bit of revision. I will see you on Wednesday.
I just wanted to check something with you real quick. When I was doing my, it's not about content programming. To Grammarly plugin. It came up that I'm assuming okay. So of course I freaked out and I went and like reworded it.
Oh, right,
But
yeah.
like,
He said it, there's a checker, right? Can it?
I don't know how accurate it is.
Yeah. Yeah.
Anything about AI.
No.
Like,
Yeah.
really scary from a point
No,
of view.
it
I want
is.
to write SQL saves and takes a long time.
Yeah. And unfortunately, Grammarly and other services make claims about the reliability of the checking that probably aren't. I wouldn't
So I don't need to like change.
No. I mean, look,
I mean, I did change the wording because I was really worried about it.
we are. I mean, we appreciate that. We are aware that there's no reliable way to detect AI use. If there's anything that's suspected, we, but we're integrated. But I appreciate it. No. Sorry, law and tech. That's part of the law and tech. So if there's any company needs that will
and which ones are being scrutinized under Section 50?
Oh yeah. So
Hi Josh.
hey, how are you?
I'm good. How are you doing?
Oh, one more.
Yeah. Or is it your quote here?
Yeah.
No, your
Oh, sorry,
quote.
yes, my jacket.
Yeah.
Thank you. So basically, 30